And is there another hashtag?
FreeQua.
Is there another hashtag on the screen?
Oh, no.
Your Honor.
It's in this paper
Your
right
Honor.
here. You got me reading.
Your Honor, I have to make a motion.
All right, I'm going to excuse you.
I wasn't looking at the screen. I was looking at this paper.
That's fine. Don't worry about it. Can I ask you to step outside for just a minute? And jury, I'll excuse you all for just a minute.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said FreeQua, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. And I made a motion for mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews for Mr. Quamarvious Nichols. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Quamarvious Nichols and has also identified Quamarvious Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Okay. So that moment right there, obviously, as Carrington Matthews said, that built off a lot of other stuff. But where were you, and did you expect that to really go anywhere? Because for people who didn't see that or didn't watch, she didn't grant the mistrial at the moment right there, but she did at the end offer to grant a mistrial without prejudice, which would allow a retrial. But that seems to have been what triggered the plea deal comments or the plea deal negotiations. So when you made that mistrial motion right there, I mean, did you expect it to go anywhere? What were you thinking?
So, this was a lot. It's a lot to unpack here because I had just, on behalf of Mr. Nichols, myself, and Attorney Bruce Harvey, we had just brought this issue to the prosecutor's attention. Okay. And then, so we brought it to her attention. Then we went up to the bench, brought it to her attention again, and stipulated that it would not be there. So it was pretty surprising when the witness ended up saying, FreeQua. So when it first happened, I turned to Harvey, Harvey turned to me like, are you serious? And we couldn't press the mic fast enough. I don't know if everyone knows, but we have these microphones, sitting at our tables, and we generally keep them off. So you have to hurry and press it on to be heard. And so, we had to hurry up and do this. Like, are you serious again? And as I mentioned in the argument to the judge, this wasn't even the first time in this trial that a witness testified in reference to our client spending time in jail or in prison. So at the moment, it was more of, we can't believe the state did this again.
Yeah.
Yes. But at the moment, we didn't really jump to conclusions on what the court would do with this happening again. We weren't even thinking about it at the time. It was more of, we can't believe that the prosecution can't get this right.
Right, because some important background here would be that's why Detective Dennis's testimony was struck as a sanction, right? Because he made a comment that indicated somebody was in jail, or what was the specific comment that he made that led to that sanction?
So he did, it seemed pretty, unprompted by the state for the reason that he did that. We have our own suspicions on why he did that, but at the end of the day, yes, he did. But a big difference is that he's a detective and a retired, APD. So he definitely should have known better. No ends, F, and buts about it. The witness that, stated FreeQua, we're not going to go and say he should have known about it. He's a lay witness. The state should have made sure that he knew. But Detective Dennis is a whole nother story. He should have known whether he was prepped or not.
So it was just kind of a culmination of these issues. And as the judge said, maybe if they didn't have this ginormous universe of evidence that they were trying to sort through, they wouldn't be making mistakes like this. Because the judge seemed to believe in, and frankly, I can kind of hear it in Simone Hilton's reaction when he reads that FreeQua quote where she's just like totally caught off guard. We can't see her face, but it does seem like she's just totally shocked. But it seemed like the judge's point was it's not intentional, but almost, I mean, intentional would just be horrible. But the fact that they're so unorganized and they still can't get this right does not bode well for moving forward. And that seemed to be why the judge was putting forth the mistrial without prejudice offer. Did you, what was the reaction when she said that? Because I mean, as somebody who was just watching at home and is kind of used to the mistrial talk and it always being rejected, when I heard her say that, my ears kind of perked up because I was like, okay, that sounds pretty serious. Have the same reaction?
Well, we wanted to continue to argue for the mistrial with prejudice. That's what we really wanted to do, because although we understood that the judge, stopped us pretty short and said, you should have seen the prosecutor's face. We don't think that, she didn't think that she did it on purpose. But what we felt was that although that particular moment may have not been on purpose, that it was on purpose not to prep witnesses. Okay.
Yeah.
So we do feel that not to prep witnesses before they take the stand, or to have an issue and say, oh, okay, we just agreed FreeQua wouldn't come. Let's talk to the witness about that. And as Matthews pointed out, this witness had just spoken about someone else's incarceration, right? So the not prepping, sometimes non-action is purposeful action, right? And that's really what we wanted to argue here, that the state, was doing this repeatedly because they choose not to avoid these type of elementary issues. Regardless of the fact, while we were sitting there, waiting patiently for the judge to finish, denying our motion for mistrial with prejudice, we really wanted to continue an argument in reference to that. But then the court said, do you want it without prejudice? And then the argument stopped. And again, we looked, myself and Attorney Harvey looked at each other, we looked at our client, and we pretty much knew at that moment, or we believed that was the time. That if we really wanted this mistrial, that it was the time to reach out and grab it. But since Judge Whitaker, only offered the mistrial without prejudice, it was a hard decision to make because the state could bring it back. And we thought it would be absolutely ridiculous for the state to try a round two. We think it's absurd that they tried round one. So you can't really predict what they would do. And so that was going to be a major decision. Trial was going pretty well as far as we were concerned. So, it was a really hard decision to make, which is why we asked for some time.
And how did that go with the state? I mean, that afternoon, were you having a negotiation? Did they come to you? What were the negotiations like moving forward?
So you have to be careful speaking on real particulars of negotiations. Sure. But we're comfortable with sharing that we do believe that the mistrial, and not just the motion for the mistrial, but Judge Whitaker saying, all right, how do you want it? Definitely applied, pressure to the situation, and started the real communication about any type of possibility of being able to resolve the case, short of finishing trial.
Because generally the thinking is that a retrial, if they did retrial, would favor the prosecution because they're able to clean up their case, et cetera, et cetera. But I just imagine them trying to get, Tick back on the stand again and having to question him all over again. And all those witnesses, I'm like, are they really going to do that? So I was kind of thinking, if you got a mistrial with prejudice, the idea that they would retry it was... But then I looked at how they were behaving in the last few weeks, and it was obvious that they were trying to get their shit together, like ramping it up, putting more prosecutors on the case. It seemed like, too little, too late. But I had this vision of what would happen if they did retry it. Like, did you have that same concern that they're going to have more prosecutors on the case? They're going to have a better judge on the case, so all the problems that they had in the first trial wouldn't be there. I mean, you've got so many things to.
It was a lot. It was so many factors. Exactly, you're exactly on the right road. But yes, generally speaking, if the state is able to, retry their case, they're going to fix their errors.
Mm-hmm.
Okay, so yes, that's true, but we couldn't safely assume and predict that they wouldn't retry this case because, like I said, let's back up. Indicting 28 individuals at the same time. Yeah. Who does that, right?
Yeah.
Evidence is a term that we use frequently, but just because the state says it's evidence, I'm not sure if we agree that it's really evidence, right? So, the state had spoken with, or at least had indication from plenty of their witnesses that, witnesses told them, hey, when we had this conversation, I wasn't being honest. Hey, you made me feel pressured. Hey, I just signed this to get out and I don't even know what this meant. So they had a lot of these, they had this understanding before they put those witnesses on the stand in this particular trial, and they did it anyway.
Yeah.
Right. So it wouldn't be smart to believe that they would have been logical and rational and
No.
and not bring around two. And also remember that we have several other individuals that's already in queue, to go to trial. So we don't know if they would have tried to, mistry us and then lump, if we would have received the mistrial and then lump us in with the round two. We're just not sure. And they probably would have, at the very least fixed some errors.